Welcome to the Real Estate Show with Pat Lopez, where we talk everything real estate. Today, my guest is Charlotte Bradley from Settle Down, Philadelphia.
Yes.
Charlotte, welcome to the show.
Thank you for having me, Patrick.
Great. Okay, so I always start off all shows by asking, how did you get started in real estate? Tell me your story.
Well, I'm trying to make a long story short. Even though I came from a family of homeowners, I never even thought about getting into real estate. I bought my first house with my husband. Well, he was the purchaser, but we were 18 and 20 years old.
Okay, so you started young.
We started very young, and I was finishing up my degree in paralegal studies, and my senior paralegal, he was like, I have a friend that's starting an investment company and he needs your help. So I need you to go over there because you're great at what you do. So that's how I got my start in real estate, through an investment company. Within 3 months, I became the operations manager, ran the whole company. And that was how I got my introduction to real estate. And I loved it.
Okay, great. Now, I met you at an event, and you gave me your card, although we've known each other for like 4 years or so. And on the card, it has, I specialize in probate and wills. Right when I saw that, I was like, that would be a great show. So a lot of people don't understand. And I actually had a phone call from somebody this week who said that their boyfriend slash fiance passed away. They were on the deed of the home. But what do I have to do? And I was like, humana, call Charlotte, right? No.
Yes, call Charlotte. Yes, absolutely.
So let's talk probate. So my question for you is, what are the steps? Like, is there specific steps, things you have to do when you're probating a property? And probate is when somebody passes.
Yes. So there are several steps, but the steps that you take depend on whether there's a will or there's no will, which is also called a dying intestate. When there's a will involved, you just get the will validated by going to the Register of Wills. If you're going to do it on your own, or you get an attorney, and then you provide the original will, and you provide the original will should list an executor on there. So if you're the executor listed on the will, you provide the original will, a copy of your driver's license front and back. You bring your driver's license if you're doing it in person, and then you have to basically, that is how you get your start when you validate the will for probate. It's just a legal process to do so. If there is no will involved, there's a whole different process. There's a lot to get into, but let's start with a will. That's the easiest way to go.
Okay, so now you go to City Hall, right? Mm-hmm. And you present the will, your driver's license, all that. Now, is there a charge to do that?
Yes, there is a charge.
It's minimal, isn't it?
It depends on the estate, but the charge is between $550, $600.
Okay, so it's not a huge number. Okay, so now once I guess you validated the will from what you said, then what would be the next step you have to do?
Well, the next step that you would have to do is you would have to complete an application to become the executor or executrix if you're a woman of the estate. Once the application is processed along with your supporting documents, your original will, then you would get your letters of testamentary if you were the executor. If you're not the executor, you would get letters of administration, which is the other process that you have to go through when no will is involved. And you also get your short certificate, and that would allow you to act as I like to call it a post-POA, post-power of attorney, post-death power of attorney. That's the best way to describe it. So you're able to make decisions on behalf of the state.
Okay. So let's go back, because you said some words that you went all over. Okay, so say that again, that you have to do what? I didn't... I know to be the executor or executrix, what forms do you have to fill out, or how does that determine? Because I know it's on the will, you just said, but
There's an application that you have to fill out to become the executor of the estate. In order for the will to be processed, your name has to be listed on the will to become the executor. Otherwise, you'll have to go through the other process where the court has to appoint the executor.
okay, so then you would have to go to court. Okay. So ultimately, when you get a will, name an executor or an executrix.
Absolutely.
Which would really streamline things.
Absolutely.
Okay, so,
And an alternate executor or executrix as well, in case the person you named as the executor or executrix cannot perform or precedes the person in death.
right, okay, that makes sense. Okay, so now that step is done. Okay, so that's all legally done, it's all good. Then what would be the next step? Don't you have like to advertise or something to make sure there's no debts or anything like that? You know, does that come in at all?
That's only when there is no, that's when there's no will and there's heirs.
Oh, okay. So once you have the executor or executrix of the estate, then you're able to then move forward of allocation, or I mean, I guess the will would also say how everything would be allocated.
Yes.
Right.
So the reason for this process, and I just want to put a disclaimer, I'm not an attorney. I am a trained paralegal of 22 years. I have my bachelor's degree. So this is not legal advice. But the reason for the legal process, yes, I meant to say that at the beginning.
Yeah,
so the reason for this process is to have the ability to distribute the assets and pay any debts that the deceased owns.
Okay, very good. So once you do that, then it's just, if a property's owned, it would be, selling and then dividing the money up, along the lines of whoever was on the will, type of thing, and just paying whatever items need to be paid off, right, at that point. Now, what would need to go to the title company? Wouldn't the title company need something to be able to clear title?
Just your short certificate showing that you have the ability to make decisions on behalf of the estate.
Okay, so that.
But it gets a little more complicated in the background. So I can go into that really quickly. Once you become the administrator or the executor, administrator, if there's no will, someone dies intestate, that's the more complicated route. But the executor, executrix, you get your letters of testamentary, you get your short certificate. You need to gather all of the decedent's information, all of their assets, all of their documentation for their assets, any investment accounts, bank accounts, all of that information they had, as well as debts, mortgages, utility bills, credit card bills, car payments, so on and so forth. You need to gather all of that information because outside of the house, that information has to be reported on the tax return, inheritance tax return.
Right, exactly, and that was the big piece of the puzzle, because there is inheritance tax potentially. What's the tax implication and all that kind of stuff. So all that information needs to get in there. Okay, so very interesting. Once again, you can see I know nothing.
You know a little bit. You need a short certificate to sell it.
There you go. So I know your number. That's the most important thing. I know your number. Okay. So
absolutely.
So now let's get into. A lot of people say if I don't have a will, really, you sort of have like the guidelines of whatever the state says. So in the case of if I don't have a will, even though I'm paying the mortgage, and let's say it's my girlfriend who passed, well, her family is in first line for that property, right?
Yes.
So it doesn't matter if I was paying for years. So that's why it's super important to have that will.
Yes, it's extremely important to have that will because then we get tied up in tangle title, also called heirs properties. And essentially, if you don't have a will when you pass, designating where your property, your assets go to, then it passes on to your heirs.
Right. Okay, so exactly. So you're thinking, hey, I paid this mortgage for the past 5 years, and you think, oh, I paid it, it's mine, and you get nothing. So that's super important, to understand that part of it. Okay, so Now, you mentioned, because we had a brief conversation before we started the pod. Now, you also mentioned it's super important how you take title.
Yes.
So explain some of that, and a lot of this when you're buying a house, if you're both on it, the title company will ask you how you want to do it. But
Yes.
jump into that.
So when you get your title done, a lot of people are not married, right? When they purchase a home, which is not an issue. Just be careful of how your deed is written. The default way to write a deed for unmarried individuals is tenants in common. And if you have a deed that's written as tenants in common, then you get half and the other person get half or a quarter or however many homeowners there is. And if something was to happen to you, don't have a will, your portion, your interest in that property will pass on to your heirs.
Right. So, and that's super important. So we buy a property together and it's tenants in common. So that means something happens to me. Well, my mother, my father, my brother, my sister, they're in line for my half.
Absolutely.
So that's tenants in common. So now when you're married, it's tenants in the entirety, right?
Yes, tenants by the entirety.
And then it automatically goes to each other.
Yes. And even if you buy the property without having your spouse on the property listed on the deed, your deed still has to reflect husband and wife. So you guys out there that's trying to get around saying you married, it's not going to work.
Right. And this is something that I get all the time too. And then we'll get into if you're not married, where it can write a survivorship.
Yes.
You know, why don't we jump into that? So we both could buy the property together.
Yes.
And then if we have right of survivorship, then it would automatically go to each other, right?
Yes. So if the way to protect yourself, or if you're an unmarried couple, or if you siblings, or so on and so forth, and you want to protect the other owner of the property, you make sure that your deed is written as joint tenancy with right of survivorship.
Right. Okay. Now
that way the property passes on to the other owner without any issue.
Right. Now the one thing that I get, and I get this from women more than anything.
They don't want their husband on it.
No, not that, not that. I get where on the mortgage, because the mortgage and the deed have to match,
Yes.
where they get, unmarried woman goes on there. You just mentioned that if it's husband and wife, even though one person is buying, it'll have, a married man or married, woman or unmarried
Yes.
or married, right? It has it on there. And women all the time goes, why is it going to say unmarried woman?
Yes.
Why? But that is for that legal aspect of
Yes.
who has rights to the property.
Yes, if
right?
something was to happen to you, because if you're married, the spouse, first of all, you can disinherit anyone but your spouse in Pennsylvania. So you don't have to leave your kids anything, you don't have to leave your family anything, but you can't disinherit your spouse.
Okay.
Your spouse is entitled to the first $30,000 plus an additional 50%.
Okay.
And there's nothing that you can do about that.
Right.
That is the intestate, the laws, not intestate laws, that is the laws for inheritance.
Okay.
So you can't disinherit your spouse unless y'all have a prior agreement stating that they won't get anything.
Okay.
You prenup
Right.
or premarital agreement, whatever you want to call it.
Right. Okay. So now, you mentioned as well that a lot of people who don't have wills, there can be issues where properties end up going to sheriff sales, those kind of things, because the family can't, get along. Nobody's paying the mortgage that's there. So explain some of those, case studies that you've seen.
So I've seen a lot over 22 years. Because every field of law, someone dies, right? So I've been doing this for a long time. I just happen to love it when it comes to real estate, more so to try and save houses from going to sheriff's sale. So what happens is when you die, they say intestate, which means die without a will. What happens is your property, your assets, everything, unless you have a beneficiary listed, goes to your heirs. Your heirs is your family members, your blood family members, or, adopted family members, because adoption is still considered blood as long as it's a legal adoption. So if you don't have a spouse, all of your assets go straight to your spouse in Pennsylvania. If you don't have a spouse, it goes to your children. If you don't have children, it keeps passing down the intestate chart to your parents, then your siblings, then your nieces, nephews, so on, cousins, so on and so forth. If you have siblings and your parents are deceased and no siblings have, one of them passed, it goes to their son. It just keeps following the intestate chart until it gets to the proper heirs. The worst case scenario, and which happens most often, is the parents die without a will. It goes to all their children. Children don't get along. Children can't agree. Children got to fight with nieces and nephews. Everybody's get frustrated because no one want to select one person. I always recommend one person to become the administrator or an administratrix if it's a woman, to handle the estate.
Right.
And they can't get along, and what happens is the property winds up going to share sale for mortgage foreclosure or share sale for tax lien foreclosure because the taxes are getting behind, the mortgage is getting behind. I'm gonna be honest, it's usually one sibling living in the property not paying anything, and then a responsible sibling paying everything. It gets really out of control. So it's very important to have a will and designate it. But if you do have that situation where you have a parent that passed away and the other parent have predeceased, that parent died before that parent, then all of you guys have to get together and decide who's going to be the administrator of the estate. And it doesn't have to be a sibling. It can also be a friend of the family. It could be an attorney. It can be someone like me that does administrator services to avoid all the conflict. The thing is, everyone has to sign a renunciation designating that one person to be the administrator. And that one person is the one that has the right to make decisions on behalf of the state. Do not confuse it with a right of ownership for all of the assets of the estate, because a lot of people get that messed up as well.
Right. Yeah. So, it could be crazy messy, especially if you have, 3, 4, brothers and sisters.
Absolutely.
And the parents pass and, everybody's arguing, we want to sell, I don't want to sell. Well, who's paying the mortgage? There's a balance, who's ponying this, who's doing that, and it's going back and forth. And then all of a sudden everybody, after a while, probably goes into foreclosure because nobody's paying a mortgage and nobody gets anything because everybody's fighting.
And that's the most common scenario. And that's why over 10,000 properties in our city alone has went to share sale because of family members either not wanting the property or can't get along to raise the estate, which is another verbiage for probate in the estate,
right,
to sell the property and divvy up the property.
Okay. That's, that's fascinating. It's super fascinating. And from what I'm hearing here, the most important thing is
have a will.
Make sure you have a will.
Yes.
Make sure you have a will, because if not, things can get crazy fast.
Yes.
Right. And there's still steps that you have to do, even if you have a will.
Yes.
And ultimately everybody has to get along and all that, but at least that alleviates a lot of the problems.
Not with a will. Nobody has to get along. You put in your will what you want done with your estate, and the executor has the responsibility to carry out and distribute how you want your estate.
Right. But if you have this property goes to the 3 kids, well, I guess, I guess they would have to get along to sell it. They would have to make a decision, or to keep it, I guess they would all have to decide, right?
That's why the attorneys I work for never agree to properties going to multiple children. And when it gets like that, we discuss the option of selling the property and putting that in your will for your executor or executrix to sell a property and distribute the proceeds, the net proceeds among your children.
Right. And that's really important as well, because you could have where family won't get along and argue with each other. Like you could have, let's say a parent paid for, you had, 2 kids. One kid went to a private college, which would cost, $60,000 a year. The other kid didn't go to college, went to a trade school that cost $5,000 a year. And the parents turned around and said, okay, well, we spent $240,000 here. We spent $20,000 for the trade school. Well, we owe, the one child the $200,000, more because they didn't do it. So we're going to give that child the house. Well, if that kind of stuff is explained and written out, then maybe there wouldn't be that animosity where, kids don't talk to each other after the fact. There was, I guess an attorney was, talking about that, saying, hey, really be deliberate, really explain, what your intentions are, to try minimizing, some of the disagreements, because there's enough hardship with, parents pass, and then you add on another layer, it's not a good situation, when you do that. So
I'm going to give an unpopular opinion. You don't care when you pass.
Right. The person.
It's not your problem anymore.
Right.
You have your reasons. You can leave a letter for each child explaining it if that's what you want to do. Because again, you're not obligated to leave your children anything. But it's your will, it's your last wishes, and whoever you select, it could be a best friend to carry out your wishes.
Right.
That's what they're going to do.
Very good. Okay, so Charlotte, you're fountain of knowledge. If somebody needs to get a hold of you because they just have some questions, how would they do that? Also, you are a realtor, you buy and sell. And
Oh, yes.
so you do all that. So you sell real estate, you do everything.
Yes.
Although, you do help people out with probate and wills and all that kind of stuff. So if somebody wants to get a hold of you, how would they do that?
I can be reached on all platforms at Mrs. B Loves Real Estate. That's MRS, initial B, Loves with an S, Real Estate. And my email is the same, Mrs. B Loves Real Estate @gmail.com.
Okay, great. I really appreciate you being on the show. This is one of the topics that I've been wanting to talk about for a while.
Yes.
And when you gave me that card, I was like a light bulb.
Yes.
You need to come on.
Yes.
You need to have this conversation. So,
I'm so happy to be here because this is a topic that needs to be talked about.
Absolutely. Well, that's the Real Estate Show with Pat Lopez. Be sure to follow the show on Facebook and Instagram. Subscribe. Really helps me out. I'm almost at 10,000 subscribers. Get me over the top. I need 10,000 plus subscribers. Really helps out the show. Do some likes. Helps out the algorithm. So be sure to watch future shows. I have some great guests coming up. And remember, this show is everything real estate, no limits. Hope you enjoyed the show, and I'll see you next week. Bye.